All right, I'm Charlie Hurst, the school board organizer with Michigan Education Justice Coalition. Thanks for joining us tonight for our Welcoming and Safe Schools for All webinar with the ACLU and Merck, and Dr. Pugh will be joining us later. So MEJC, as you know, I'm sure, we're a statewide coalition that envisions a future where every student can access a quality public education. And we envision a public school where school board members are transforming our educational system to develop change agents to empower their communities. Tonight, we're going to be joined by Dr. Pamela Pugh, president of the Michigan Board of Education, Jay Kaplan with the ACLU, and Anna Devereaux with Merck. But before we hear from them, we are going to do some breakout rooms, okay? So the breakout room, Amani is going to be setting us up into breakout rooms and putting everybody into different rooms. What we're going to be discussing in these breakouts is what is the current climate in your community. So we want to discuss what are you seeing in your community. I know not everybody has probably gone back to school yet, but we are very we're starting to feel aware, whether it started or not, of what we're going into this school year. So I'm curious, for those who have gone back or even at the end of last year, has absenteeism increased because students are afraid to show up? Were there any increases in hate speech? Do more students need SEL supports? So I am going to give Amani, Amani has opened up those breakout rooms. So we'll be in here for about 10 minutes, okay, everybody? So let's talk a little bit more about our agenda today. As you can see, we wrapped up the breakout room, and then we will talk about welcoming all students with Merck, protecting LGBTQ students with the ACLU, and then we will be talking about the courage to lead with Dr. Pugh. So let me turn it over to Anna Devereaux from Merck. She's going to tell us about the current anti-discrimination laws in Michigan and at the federal level, including how to respond to immigration enforcement in your districts. Take it away, Anna.
Hi. Hey everybody, I am Anna Devereaux. I am use she, her pronouns. I'm one of Merck's senior managing attorneys. I'm glad to be with you guys today to share a little bit about the immigration context in the educational setting. The disclaimer at the outset is there's more content on the slides than we plan to spend a lot of oral time on together, partly so that you can have the more detailed versions later. And always happy to answer more questions at the end if we go too fast on anything as we're going throughout. But for those of you who don't know Merck, we're the Michigan Immigrant Rights Center. We are a statewide legal resource center for Michigan's low-income communities, where we're hoping to continue to build a thriving Michigan where the immigrants community can belong. We have two sort of focuses of our legal services directly, direct legal services. One is employment law and the other is immigration. And we have two separate hotlines for that, or intake lines. So if you know anybody in the community who has an immigration question or an employment law question and they are a migrant worker, we are happy to have them call us free of charge and try to get an answer to their questions. And so that resource is there. And as we go talking, we just like to frame the reality that our immigration system, like many other, or maybe every system of the United States, has its origin and its intentions are racist. And specifically, it was framed that anti-Black racism and anti-Indigenous racism are foundational, both in our country and the specific tactics that we see used in immigration policy and law are pulled from those other parts of our history. And we continue to see them today, even in policies that seem neutral. They have this undercurrent and this purpose. And so in the law, we have including in immigration law, very specifically white identity as a racial identity and construct that creates a legal caste system. And so we're going to spend a lot of time. We have a whole presentation on racism and immigration law. We're always happy to share if anybody would like that separately, but we just want to make sure we're acknowledging that as we talk about these systems. And so the system isn't broken. It's doing horrible things, but it was meant to do that. As a sad note to get us started, we can always keep fighting, but that's kind of where we are framed within that. And so we're going to talk today about the changes in sensitive policy locations, the specific laws protecting students regardless of immigration status, and tips for establishing procedures for when enforcement occurs on the school campus or related spaces, and protecting the privacy rights of all students. And specifically, we're going to have a small note on security officers in the school and just generally some other resources for welcoming students. So the big change, and I'm sure most of you are already aware of this, it used to be the case that Immigration and Customs Enforcement, so the federal agency that uh, is in charge of enforcing immigration law, the police essentially for immigration contexts, had a rule that they would not go to certain sensitive locations in order to detain somebody or initiate immigration proceedings against them. And there's a longer list, but it included schools and school-related locations like bus stops, school playgrounds, etc. And the beginning of the Trump administration, and this time around, that policy was rescinded. So they are allowed to, under their own policies, now undertake enforcement actions at schools. It doesn't change the other protections that exist for children and staff and anybody who may be at a school, but but it makes it more likely that there may be enforcement action, and therefore these discussions are more important in this moment in time. And so we'll kind of go through the different rights as it relates to the school context. So sure, this is old news to everybody, but because of Plyer v. Doe, all children are entitled to K through 12 education, regardless of immigration status. So in practice, what that means is that schools cannot ask for proof of citizenship or immigration status, even if it's for another stated purpose, like showing residency in the school district. They cannot require documentation that's not available to non-citizens, such as a driver's license, specifically in the state of Michigan, social security card, or U.S. birth certificates. They can't request additional documentation from certain group of students that they don't for others, and they can't use immigration status or national origin to discriminate in any way. But they can ask for proof of residency in other ways, like an address, utility bill, something like that. And they can use a student birth certificate for their proof of age if that's the document that's provided. They can ask for Social Security but cannot require it. Yeah, was there a question? So just some Michigan laws now, but we'll get into a few more federal laws, but Michigan's protection for students' access, regardless of immigration status, is broader than the federal. So children 5 through 20 can access in Michigan's public schooling systems. And we also have rights protecting against discrimination in the school context, from discrimination against religion, creed, race, color, national origin. We also have the Michigan Elliott-Larsen Civil Rights Act, which provides this protection against discrimination from a variety of categories that one may belong to, including one's national origin. And the McKinney-Vento Act does not specifically address immigration status, but it is a tool that can address, provide resources and protections for children who are affected by homelessness, regardless of immigration status as well. And a note that came up in our preparation, like, is this coming up more for our students? One thing that is a reality for students right now, and families in general, is that a lot of caregivers are now being deported, and that may leave children without housing resources in the long run. So we may see more immigrant students needing to take advantage of McKinney-Vento protections. We also have FERPA, and so the specific protection here is that schools are prohibited from providing student information to anyone, including ICE, without parental consent. And so I'm sure you guys are used to, navigating that on a regular basis around general provision of information, but the request from immigration officials for information does not override FERPA. And so that's an important reality that all of the schools have to acknowledge and know that if they were to violate FERPA, they would be held accountable for that. And so this is just this place for offering that reminder and talk about that more. And so the records are private, except for directory information that you otherwise share publicly. And so enforcement actions that may occur in school. So if ICE shows up attempting to ask information to locate an individual, Fourth Amendment rights apply in a school context. Generally, the Fourth Amendment applies anywhere where there's a reasonable expectation of privacy. And so a school is one of those places. And so schools can require a warrant to search those private spaces, including anywhere in the school. Most school buildings are generally closed off if someone doesn't have another specific reason for being there. And so they would be within their rights, a school to require a warrant for the presence of any ICE official. And so we encourage schools to develop a specific protocol of how to engage with ICE if they were to show up on campus. I heard some good chat in my small group about most of the schools that folks were representing there already having these protocols. So that's really great news. So this may not be news to you guys, but feel free to share it for any school districts who it is new and they haven't figured out this information yet. And so some of recommendations around those procedures is one, just making sure you just think about what would you do as a school district, who is responsible for which part of this step, and consulting with your legal counsel is a really important part of that. And so that in that preparation, you're working to make sure the students' rights are protected above all. And knowing how to comply and when you need to comply with judicial warrants. So there's a lot of information on warrants here and the next few slides. And then there's some resources that will be shared out as well. The bottom line being that Immigration and Customs Enforcement will often present a warrant. And they'll call it a warrant, and it in some ways is a warrant, but is not the type of warrant we are typically talking about when we talk about Fourth Amendment requirements for a warrant to access a space that you're otherwise not consenting for some law enforcement to access. And so the ICE warrants are not legally binding. They're not signed by a judge. And so you do not have to typically comply. You don't have to comply with them. So the warrant that's presented, if it's a administrative warrant, schools don't have to comply with it. And so that's one of the really big reasons for developing these protocols that include having a designated person to review the warrant to decide whether ICE or other law enforcement get access to the premises and the students, because it's not necessarily intuitive, and it will take legal review to determine whether they are allowed in and whether the warrant would permit them that access. So in these procedures, we encourage things like clearly demarcating the public and non-public areas of your school. If things like playgrounds and sports fields are open to the public during certain hours and not during others, you can post signage, establishing that protocol of who is going to make those decisions. There is a great example from the Grand Rapids public school system that we have a link for that'll be shared out, and you guys can look at that, and that they've gone through these steps and established that for themselves, and training everybody on this. And so that they know that who is and is not allowed to make a decision whether ICE is allowed to come in. Um, and just making sure that these things are implemented with all law enforcement, not just someone that is visibly an ICE officer. ICE officers often present, and now more than ever, in ways that are not clearly marked as someone being from immigration enforcement. So these protocols should apply universally to all law enforcement, not just clearly marked immigration officials. And so that attorney review of warrants is really helpful, and documenting whatever happens, and making it clear that that documentation is happening for the school's protection and students' protections. And so just sort of, again, I think we'll kind of skip over this. Most of this has a lot of the information. We talked about what can and can't be shared, and you can go back to it later. And then talking about go back a slide or two. Um, just a note on, I think we can go to the next one on the, well, thanks, on the security officers. So a lot of schools have their officers that are part of the school system that are there for different purposes, according to their kind of engagement with local communities and local law enforcement agencies. But the important thing here is that under FERPA, these individuals, while they may be employed by local law enforcement agencies, are considered school officials and are required to comply with the school's obligations under FERPA and the Fourth Amendment. And so it's important to go through with those officers. Ideally, we recommend having them sign documentation to agree to comply with the many different ways in which that FERPA requirement might show up, but specifically in the immigration context, that they would not be seeking out any information about immigration status and they would not be sharing any information about students' immigration status, and they are not there to detain students or family for purposes of immigration enforcement, and that they should look to generally acknowledge and work within the legal requirements that schools have to protect those students. And there are often instances in which these officers are expected to enter information into databases. And that's part of the liaison relationship they have. And that's something we encourage schools to examine really closely, whether that serves their students, generally speaking, because obviously the more information law enforcement has about our students, there can be more negative consequences for them down the line, regardless of immigration status, but particularly obviously in this context, that can have a really significant effect on their ability to seek protections that they may otherwise be eligible for if school officers are reporting things that are otherwise normal part of school discipline or other things like that and reporting them in law enforcement databases. And so that's something that schools should be quite cautious of and make sure that they understand anything that officers in their school system are generally reporting, and decide whether that works for their students and when that works with the school district's requirements to comply with the Fourth Amendment and also with the with FERPA. And generally, students also have their Fifth Amendment rights that they do not ever have to engage with law enforcement, don't have to speak with them, don't have to answer questions. And that applies in the school context and making sure that there aren't instances in which these officers are because of the relationship with the school, it's giving the impression that they have to comply in ways, whether it's searches or and conversations, that they otherwise would maybe feel recognize that they don't have to do that under the Fourth or Fifth Amendment. I think we have the next slide is a few resources for students.
Anna, before we move on to the next slide, we do have a question in the chat. Are classrooms considered private, or professor teacher offices? Do they need to have, doors closed to be private? Can you speak to that for us?
So in the K through 12 context, I mean, I think generally it's going to be based on how the space is generally used and how it's set up. If it's a space that is most of the time closed to the public, like you have to show ID or sign in as a visitor, that would be considered to be private. You're getting allowed access anytime you come in. The use of professor makes me wonder that, maybe we're talking also about a university context. I think that when universities tend to be a lot more open than K through 12 settings. And so if it's a space that is generally, you don't have to present ID or show who you are to walk in or have a key, that might be considered more public. So keeping doors closed definitely helps show that it is private space. One thing we're doing even in our offices is putting signage that indicates that it's private space. Even just the word private put on certain locations can help with that so that it's clear that we are saying this is private. If law enforcement walks through without anybody giving permission, that they're doing so in violation of the Fourth Amendment. So definitely additional signage or steps like closing doors or using keys in places that maybe you've gotten used to accessing it without a key, leaving something unlocked. You might consider who's using it and maybe if it would be helpful to develop a new practice around keeping things a little bit more closed off while still allowing access to the population that needs to be in that space. Great question. And so the other things are obviously as you're developing these policies, communicating it really clearly so that your community members feel safe and feel that this is a space that they can go, even though they have the right to be there. It can, with all of the messaging happening around them, it can be hard to know what's safe. And so the more the schools communicate these practices, the better. And then we have a tool out here, we call it our Family Preparedness Guide that we encourage folks to use to get prepared on an individual and family basis for any potential encounters that they may have with law enforcement and immigration, including having a delegation of parental authority if they were to be detained, and designating who would receive their children and other resources like that. And so we encourage schools to have these available and share them with families who may need them, and also figuring out what relationship could be helpful, particularly around receiving some of that information so that they know who's this child going to if the parent is not available. Rather than having to call CPS, they know what other person is designated to receive the child. And here is an assessment that you guys can use on your own time, meant for districts and schools to go through and just kind of see with these resources and policies, how are they doing, what could they work on and develop a little bit further. And so these are just some other links and resources that you're welcome to explore and keep in touch with, or to, get more information as you go along. And just the reminders of what we've already talked about, that our students have federal and state law protections of their right to education and privacy, regardless of immigration status. And educators and schools officials are not required to share immigration officials, and your spaces as educators and officials have Fourth Amendment right protections, and confidentiality requirements apply in those contexts. And we would encourage the development of those policies so as not to interfere with the student's right, even when there are enforcement or officers that are part of the school system. I think that is all from me.
I did see
Thank
one
you
more
so
question.
much, Anna.
I
Excuse
did
me.
see one more
Um,
question, Charlie, in the
yeah,
comments really quickly, from Sarah Johnson. Have you heard of any instances where ICE has utilized SROs to detain or search students or their families?
I apologize. I don't think I know what the term SRO is here. Um,
school resource officer.
oh, okay,
So,
thanks.
yeah.
I'm not aware of any in Michigan, and I don't think I've heard any national stories either. I think that my guess would be the more likely context is just the general information sharing could lead to other enforcement action more broadly, but I'm not aware of any specific examples yet, which is great.
Thank you. Great question. And Anna did Anna throw a lot of information at y'all. It will be sent out after this, along with a recording to tonight's Zoom and links to the PowerPoint. So we're going to be sending you all of the links. Now, Jay is going to tell us about school districts' obligations to protect LGBTQ students from discrimination. So take it away, Jay.
Thank you, Charlie. So, just briefly about the ACLU. Sometimes we get mixed up with the AFL-CIO. With it stands for American Civil Liberties Union. We're a nationwide, nonpartisan nonprofit. Our mission is to realize the promise of the United States Constitution for all, and to protect and expand the reach of its guarantees. And every ACLU, every state has its own ACLU affiliate. And so the ACLU of Michigan's been around since 1959. And the ACLU as an organization, a national organization, has been around for more than 100 years. And we do what's called integrated advocacy. We do provide legal representation in impact cases that are going to have an impact on a large group of people. We do get involved in public policy issues, both at the state and federal level. We do a lot of work on community engagement and education Education through our communications department. But we really work together as a team. It's not just the lawyers working on a case. We work with the communications division. We work with our public policy group. So I wanted to start out with some important laws and responsibilities of school districts. First of all, in 2024, our state civil rights laws were amended to include the explicit categories of sexual orientation and gender identity and gender expression. And that covers employment, housing, this large, broad term called public accommodations, and education, meaning that both LGBTQ plus students and LGBTQ plus educators are explicitly protected under our state civil rights laws. And that's very important because, well, first of all, it took 46 years to amend our state civil rights laws to finally get these explicit protections. But also, Michigan is only one of 22 states that has their own state civil rights protections. And we do not have any explicit federal civil rights protections for sexual orientation and gender identity. So we have to rely on interpretations of laws that prohibit sex discrimination. And the law that prohibits sex discrimination in schools is called Title IX. That's the federal civil rights law. And we've seen a number of federal courts interpret Title IX as protecting LGBTQ students, and in particular in cases involving discrimination against transgender students, because we're seeing more attacks against transgender students. Courts have also held that that's a violation of Title IX. For many, many years, presidential administrations through executive orders have indicated that LGBTQ students are protected under Title IX. This particular administration, the Trump administration, has issued a number of directives indicating that Title IX may not protect LGBTQ students against discrimination at the federal level. And that's why it's doubly important that we have our state civil rights laws protections. Regardless of whether Title IX protects LGBTQ students, in our Constitution is a provision called the Equal Protection Guarantee. So anytime a federal government or the state singles out a group of people for discriminatory treatment, they can challenge that based on the Equal Protection Clause in the Constitution. And what the courts, federal courts, will do is they provide different levels of constitutional scrutiny. Some levels are much more deferential to what the government is doing. So I'm not going to get into too much detail. The lowest level of scrutiny is called the rational basis, and all a state has to prove, or the federal government has to prove, is that this is rationally related to an important governmental purpose. But we also see more heightened levels of scrutiny where it's more difficult for the governments to justify that discrimination. And 5 years ago, there was a Supreme Court decision, United States Supreme Court decision called Bostick versus Clayton County. Now, it didn't involve school issues. It was about employment discrimination. And what the courts held is that when you discriminate against LGBTQ employees, you do so because of sex. And that violates Title VII, which is the federal civil rights law that prohibits sex discrimination in employment. The Biden administration said, okay, we're going to take Bostock, that decision, we're going to apply it to other areas of the federal government, including the Department of Education. This is important because this means when you discriminate against students based on sex, LGBTQ students, it takes heightened constitutional scrutiny, which makes it much more difficult for the government to justify that form of discrimination. But of course, the Trump administration is arguing once again that Title IX does not protect LGBTQ students, so rational basis, the most deferential scrutiny would apply to that kind of discrimination. And of course, our state constitution also has equal protection guarantees. Another level of protection is our disability civil rights laws. So when we're talking about transgender students, many transgender students have been diagnosed with a condition called gender dysphoria. And some courts have recognized that gender dysphoria is considered to be a disability for purposes of the Americans with Disability Act. as well as state civil rights laws. And so there's been a number of court cases, not in Michigan, but in other states that have said that a transgender student is also protected under civil rights laws that prohibit discrimination on the basis of disability. All right, I think we're ready for our next. Okay, so how are courts addressed the various issues? As I mentioned to you before, we're seeing this unprecedented attack against transgender students from this administration, which has issued 9 executive orders targeting transgender people regarding passports, access to health care, being able to serve in the military, being able to play collegiate sports, and being able to be recognized by their school district for who they are in terms of with their names, their pronouns, being able to access restrooms, being able, if you're a female transgender student, to be able to play a sport in accordance with your gender identity. But this is an executive order that we're going to talk about next. But courts have looked at the issues of transgender students and access to restrooms, and we've seen a number of court opinions that say that have issued what's called an injunction. In other words, they've stopped a school district from discriminating against transgender students, and they've based that on the reasonable likelihood that this violates Title IX, that federal civil rights law that I mentioned to you, that violate, that says it's sex discrimination to deny a transgender student access to their restroom. In addition, we believe that our state civil rights law also prohibits school districts from denying transgender students access to restrooms in accordance with their gender identity. We've also seen challenges at the federal court level about transgender students being denied the ability to play sports in accordance with their gender identity. I don't have enough time to get in an editorial, but I think what we've seen is in this area of sports, the opposition has created this narrative many times that's not based on truth or actual factual information. It's almost taken as a given that a transgender girl playing sports has an unfair competitive advantage, and that's not really reflective in the reality of this. The other thing that's important to keep in mind about transgender girls playing interscholastic sports in Michigan is that our Michigan High School Athletic Association does an individualized assessment of each transgender girl and determines whether or not they are eligible to be able to play in interscholastic sports. And just as a statistics to show you that an inordinate amount of attention is given to this issue when we're talking about a relatively small population. In the past 20 years, we've seen about 10 transgender girls participate in interscholastic sports. So we're talking more than 800 public school districts in the state of Michigan, 10 girls in the past 20 years. Currently, no transgender girls that we know are playing in interscholastic sports in accordance with their gender identity. And yet we see legislation introduced in Michigan's legislature that would have a ban on this. It's also important, in Michigan, we have a law that prohibits bullying and harassment, and it requires school districts to have to do something, to have an anti-bullying policy. They don't require school districts to specifically recognize harassment of LGBTQ students as a form of bullying, despite the fact that LGBTQ students disproportionately are the victims of bullying. However, we do have a number of court decisions, including a federal court decision involving a Michigan school district, and it pretty much set the template for the law. So when I first started working for the ACLU in 2001, a lot of times the response of a school district to a bullying of an LGBTQ student was, okay, well, if it's so bad, just be homeschooled, just don't come to school. And or if you didn't act that way, you wouldn't have a problem. And obviously, that's not an acceptable solution. And sometimes we would hear from school districts, well, we tried to figure out what was going on, but we really couldn't get enough information. And, it's just kids acting like kids. The law from this case, and it was called Patterson versus Hudson Area School District, which is on the western side of the state. It's if a school district is responding to the bullying and their response clearly is ineffective. In other words, the bullying and the harassment continues. A school district can be liable for deliberate indifference. And in this particular case, there was a high school student who was harassed because he was perceived as being gay. He was actually sexually assaulted in the locker room by other students, and he ended up dropping out of school. And the school district was found liable for more than $800,000. Even though, they half-heartedly tried to investigate, they never pressed charges against, students that were doing the harassment or really taking effective action because it culminated in this sexual assault. They were found to exhibit deliberate indifference. All right, next slide. I mentioned to you about the number of executive orders against transgender students. And by the way, transgender people make up about a half of 1%, but here you have an administration issuing 9 executive orders against transgender people. And as I mentioned to you before, saying that we don't even recognize transgender status under our federal civil rights laws pursuant to this executive order, that there's only 2 genders based on what was assigned to somebody at birth. And as it pertains to school, the Trump administration has issued an executive order threatening to take away federal funding from any public school district that supports the social transitioning of trans students. And the examples they've given, which I mentioned to you before, acknowledging a transgender student with their name and pronouns, bathrooms, and allowing transgender students to be able to play sports. Now, I just want to reiterate again, those types of things are required by our state civil rights laws. The executive order is in direct conflict to what our state civil rights laws say. A school district that says, okay, we have to comply with this because we're afraid about using federal dollars would be in violation of our state civil rights laws. Um, what we've been seeing is so far, the Trump administration has not been investigating any Michigan school districts for doing what we consider to be the right thing. And we've been seeing many school districts getting the correct legal advice that school districts are responsible for following our state civil rights laws. But we have seen this administration do investigations in Virginia with regarding transgender students in bathrooms, in Maine, regarding transgender female students playing sports. And I think eventually what we'll see is litigation over this issue. Actually, the Supreme Court has taken up a case involving states that have bans on transgender girls playing school sports, and we'll see a decision from the United States Supreme Court next year. But this is by trying, to threaten about the federal funding or the share that public school districts receive. This is a way of trying to get school districts in Michigan to not follow what our state civil rights laws say. So I think the next slide talks about executive orders, and I probably should put that before this one. So it's important to understand what an executive order is. A president is not king. He doesn't just issue an executive order and it becomes the law of the land. Executive order is a policy directive that's issued by the executive branch and can always be rescinded by the next president. And we see that all the time happening. And this administration rescinded a lot of the Biden administration guidelines concerning schools and LGBTQ students. The other thing is executive orders have to follow and are subject to the Administrative Procedures Act. In other words, president can issue an executive order, but it doesn't automatically take effect. They have to first issue administrative rules, which can be allowed for public comment, and then once they start implementing those rules, then those rules are subject to challenges by the judicial branch. In other words, we have separation of, we have checks and balances between our different branches, the legislative branch, the judicial branch, and the executive branch. And it's the judicial branch that can stop the enforcement, can declare unconstitutional executive orders from presidential administrations. And that's very important. That's why we're seeing so many legal challenges in courts. Challenges right now about prohibiting transgender students from being able to play sports. Challenges now about DEI initiatives in school, and eventually, we'll see different decisions coming out from the federal courts, and ultimately, probably these cases will go up to the United States Supreme Court. The other thing that an executive order cannot do, they cannot usurp already federal court established procedure. So, in other words, if we have federal courts saying that when you deny a transgender student the ability to use restrooms in accordance with their gender identity, that violates Title IX, a presidential executive order cannot undo what that court said. It can't undo what a court has said with regarding school sports, or in terms of discrimination actions brought against school districts that won't acknowledge a student's name or pronouns. They can't undo that. The executive branch doesn't have the power, and under the Constitution, to undo federal court precedent. The other argument that can be made is that an executive order can't undo a state civil rights law. In other words, our state civil rights laws make it absolutely clear that you can't discriminate against LGBTQ students in Michigan schools. And an executive order can't say, I don't care. You have to discriminate. Now they can try. They can try to say, we have federal funding and we could try to take away some of your federal dollars because of that. They can attempt to try to do something like that, but they can't say to a state, you can't have these civil rights protections. We have, these principles of federalism. In other words, we allow our states to decide, our own curriculum, what we want to do, and we allow our states also to decide what's important to us, our values in terms of what we want to prohibit, in terms of discrimination. So as I mentioned before, we're seeing a number of legal challenges to the Trump executive orders. Right now, we haven't seen injunctions, what's preliminary injunctions issued at this point in time. We're seeing briefings. We're seeing, we haven't seen any school district lose its funding from the Trump administration because they have to do that through an administrative procedure, which can then be challenged in federal court. But stay tuned. And I think as this administration becomes more aggressive with school districts and with states, we will probably see more challenges with regarding that. Next. So we're also seeing, in addition to this administration with the executive orders, we saw even years before that efforts to try to remove or sequester, move into other areas of public libraries as well as school libraries, LGBTQ related books and subject matter. And we always go to the principle. The United States Supreme Court in 1980 issued a decision about book banning by a public school district, and they basically said if you're banning a book because you don't like the ideas contained in the book, that violates the First Amendment, that's unconstitutional censorship. Now, school districts can say, a book might have too much violence in it, might have too much sexual content, or maybe too much profanity for those reasons, but they can't single or target a certain type of books or subject matter because they don't like that subject matter. And so the law is very, very strong on that. But we see efforts in our public school districts to have books removed. There's a group called Moms for Liberty. They have a list of books. Probably 9 out of 10 of those books lists are books that contain LGBTQ subject matter. And we've seen it also, with the public libraries. But the law is very strong about that. And clearly public sentiment's very strong. The large majority of Michiganders believe that this kind of censorship is wrong. They don't support that. They say, what, if a parent doesn't want their kid to read a book at the public library, they make that decision. Somebody else doesn't decide that. So what we're starting to see at the public library level is less saying we're going to remove that book, but we're going to move that book to another section of the library, which makes it unavailable to kids. Maybe you need to get a permission slip or your parents' consent to take it out, or labeling LGBT related books as sexually explicit. There's also been court decisions saying that that's unconstitutional censorship. So we're keeping an eye on all these efforts, and we're, we're ready to challenge those efforts to try to that form of censorship. But we're also seeing at the school level efforts by individuals and school districts to try to prevent any LGBTQ related curricula from being, part of the school's overall curriculum. And recently, the United States Supreme Court issued an opinion in the case of Mahmoud versus McKnight. It involved a school district that, as part of their curriculum, had some books for younger students regarding LGBTQ subject matter. So a book about Bobby has a gay uncle, or I can't think of all the different titles. And there were a group of parents that wanted to opt their kids out of the lesson plan, saying that talking about this subject matter violated their religious freedom, their rights to instruct their children in terms of their religious beliefs. And the Supreme Court, in a 6-3 decision, held that yes, parents can opt out their kids from different curricular matter based on religious beliefs. And we believe this is very going to be highly problematic and very difficult for schools. How do you teach a class? Because we're not just talking about LGBTQ subject matter. Somebody might have a religious belief that maybe women should not be working outside the home. And there might be a story about a working mom that they want to opt out. And this is part of an effort we've seen in other states, the don't say gay laws that say, you can't talk about LGBTQ subject matter in public schools. And this is kind of another effort. And it's very disturbing. And, I'll just say this Supreme Court has been opening that door wider and wider and wider regarding justifying discrimination in the name of religion, particularly when it pertains to LGBTQ people. Saying that, faith-based foster care agencies can refuse to work with LGBTQ families based on their religious beliefs, but they have to also get state money and state dollars to be able to do so. Last thing I wanted to talk to you about was student privacy and the issue of parental notification. There's also been a lot of pressure from the Trump administration that any student who proclaims that they're transgender, that the parents need to be notified. Well, we always want to encourage communication between school districts and parents, and hopefully to have an open dialogue to work together to support students. But we also know that not every student, and particularly young people who are LGBTQ, have the support at home. And if that information was to be shared with their families, they could be actually at risk for harm, and including physical violence. And so it's important that school districts do not have blanket policies saying that automatically they're going to inform, that they do and having a conversation with the student, and they do an individualized assessment if it's necessary to communicate that information, and if there would be harm to that student. And we know that for more than 50% of all homeless kids are identify as LGBTQ. We know that this is an ongoing problem. If they do know that there could be harm to that student, that they, maybe not share that information, and they can communicate that, the student's legal name with the parents and stuff, but they don't necessarily should share that information, because a school district could be legally liable for any harm that comes to that student. And believe it or not, students, minors do have privacy rights, and there's a number of federal court decisions saying that a minor's sexual orientation or their gender identity is highly private information, and it can be protected in certain circumstances. And where school districts were found to violate the privacy rights of students when they disclosed sexual orientation or gender identity to the parents without that student's consent. There was a case. I always like to bring this up, a federal court case about 20 years ago, where law enforcement threatened to out a youth to his parents about his sexual orientation. He ended up committing suicide, and the police department was found legally liable for damages to the family related to the loss of that young person. So my advice always to the school districts, yes, you want to encourage open communication, but when a child comes out as gay or transgender and we're offering support, part of that conversation with that student is, does their family know? Could they tell their family? If they couldn't tell their family and they're concerned about that, and that information is shared, then that privacy needs to be respected for based on a school district's duty to provide a safe and supportive learning environment for that student. So I think I'm 3 minutes over. I'm sorry, Charlie. And
So thank you so much, Jay. And we are, I think, coming up to this question about the process. So we have a question in the chat. Is there a process for students and or staff to file a complaint of LGBTQ discrimination in Michigan?
yes, yes, I'm glad you mentioned that. And, it used to be we could go to our U.S. Department of Education, in other words, the Division of their Civil Rights, and they could also take a complaint and investigate. Our information and belief is that the Trump administration Department of Ed is not going to take seriously or as a priority any civil rights complaints involving LGBTQ discrimination and probably even less likely racial discrimination complaints, that their main focus is what they believe in terms of religious discrimination based on people's religious positions, as well as what they believe to be sex discrimination against by recognizing transgender students. So I would not see that as a viable option, but we do, fortunately, our Michigan Department of Civil Rights, because we have those explicit civil rights protections, what a person can do, what a school district can do, is you can file a complaint. There's an online process for being able to do that. The Michigan Department of Civil Rights will contact you, will write up a complaint. They will decide whether or not to do an investigation. If they take the case and they decide to do an investigation, they will come up with the results. If they believe that civil rights laws have been violated, they convene an administrative hearing before an administrative law judge that's brought by the Michigan Department of Civil Rights, and they can issue charges against entities. So that's the process. And I highly encourage, a number of years ago, the Michigan Department of Civil Rights was very understaffed. It was a very long period to be investigating complaints, but they since have gotten the resources to have a much more robust staff. And this is really probably the best place, and really, I hate to say it, the only viable place to go if you have a discrimination issue involving happening in the schools. So contact the Michigan Department of Civil Rights.
And then there's just one more question, and I think we'll be sending this out, but know your rights information on like Title IX that we could share to like educate students and
Sure.
school districts.
Yeah.
So
And
yeah, we will
you're right.
definitely.
And people should be expected to know all this stuff right off the top of their head. It's important to have those resources. And I can say that things have changed drastically at the federal level since this administration took office in January. And a lot of policies and procedures, and as I mentioned before, priorities have kind of just been totally flipped around.
Thank you so much, Jay.
Thank
I
you.
appreciate all that information, and we will be sending out tons of resources. So now I would like to welcome Dr. Pamela Pugh. She is president of the Michigan State Board of Education, and she is joining us tonight to hopefully inspire us to lead with courage. So, Dr. Pugh, how can school districts respond during this unprecedented attack on public education? And how can school board members lead with courage in this moment that we are in?
Well, I've prepared some words. These are interesting times at best, and let me first start by thanking you, Charlie, for thanking Michigan Education Justice Coalition for bringing us together. And this is a critical time. I haven't had a chance to listen to all of the wonderful presenters and the information that has been shared, but I'm sure what has been shared is those words that we're using, critical time, unprecedented times. But I must say that I'm honored to be a part of this important conversation. And we know, and I looked and I saw who some of the participants are. I know I'm singing to the choir, but that we are entering a school year unlike any other. And this is one that's marked by growing attacks on truth, growing attacks on inclusion, and on our very public school system. And in this moment, the responsibility to lead with courage has never been greater than today. So, my charge, Charlie, to board members, to educators, to advocates, is that we must ensure that our schools are more than just buildings. They must be sanctuaries. We must make sure that we present these spaces as sanctuaries, places where all students are safe, where all students are affirmed and free to learn. That means creating policies that don't just respond to civil rights violations after they happen, but prevent them before they occur. We need to be proactive, not just reactive. We need to model leadership that is unapologetically inclusive, leadership that protects our LGBTQ plus students, our immigrant students, our Black and Brown students, students with disabilities, our rural children, all students who have too often been pushed to the margins. And in my role, I've been proud to stand against harmful laws, discriminatory practices, and extremist rhetoric that threatens our schools and our communities. Uh, but just like MEJC can't do it alone, I can't do it alone. None of us can do it alone. So my ask back to you, and well, not necessarily you, Charlie, and MEJC, but those on the line, will you choose courage over comfort? And that is really, at the end of the day, what we have to do and the answer to your question. And Charlie, I can go on and give some examples of things that we're doing, but also some, again, some levers that we can each pull.
Yeah,
Okay.
I would love maybe you can share some like optimism because you have been so proactive and Dr. Rice and so vocal in your support for, equity and maintaining that in our public education. So, what do you see coming up this school year that we can kind of point to for hope?
Well, I would say what I've seen across districts and across geographies, across issues, is people coming together. We have to come together. And that has been one of the beauties, if you want to call it that, that I've seen is people across issues, across geographies that understand that we have to stand and we have to fight together. Jay gave us some levers, just knowledge, just continuing to understand the law. And of course, as soon as we understand one part, that shifts. There's a ruling, there's a temporary restraining order, or there is an appeal, but we have to just continue to educate ourselves. But at the end of the day, we have to stand up and we have to be bold for children, and we have to use whatever position that we're in and whatever table that we have been honored, blessed, sent to sit at and have a chair to pull up to, we have to make sure that we are carrying the voice and the fight of the people who sent us there. And it's a courageous, and sometimes, I call myself a glutton for pain, but we have to make sure that we're carrying that voice and that fight whenever we get that opportunity, and be prepared, because you're going to have that opportunity. It's going to present itself. We, those of us who are on this call, um, we just have to know that that time is coming where it's going to be our turn. It's going to be our duty to stand up for our children.
Thank you so much, Dr. Pugh. Those words were very inspiring. And I do want everyone in our schools, whether you're a school board member or if you're a teacher, staff, whatever position, I want you to think of yourself as a frontliner in this fight to prevent discrimination. So you really do need to be proactive to prevent discrimination this year and ensure that we do have a welcoming and safe school environment for all students. And I appreciate everyone coming this evening. I know it's a very busy time of year, but we do appreciate it. And we are going to send out a recording and links to all of our resources. And also, we have lots of contact information that we will be sending out, and it's included in this PowerPoint presentation. MEJC, we are always looking to improve our webinars and learn from our events. So I'm dropping a link in the chat to a feedback form. We would love to hear any feedback you have on tonight's training. And I do want to say we are going to be sending out Heal Together's Equity School Board Toolkit, which includes a lot of model policies and resolutions. You might look through these and find something that you would like to bring up policy to vote for your school board to adopt, or resolutions. We are including a Welcoming Schools for All resolution. Dr. Pugh, did you have a comment? I'm sorry.
Well, one
I
of the things that I did want to say, Charlie, that I didn't get to
yes,
say, and it bridges to what you're saying, and maybe it's been said already, is that we have to advocate for a budget.
yes.
So
Thank you.
I hope that we've talked about that and making sure that we're talking about the budget, because if we don't have categorical dollars, if we don't have mental health dollars, if we don't have the supports for educators for literacy, then some of the things that we're talking about are going to be hard to do. It's a heavier lift if we don't have a budget, and if we don't have a budget that centers children. So continue to lift your voice there.
Thank you. Absolutely. And I do want you to know that in the slideshow, we have contact information, and then we also have links to the toolkit, and we will be sending all of these out. If any questions or concerns come up, you can reach out to me or, Jay or Anna at the ACLU. We all know how to get in touch with Dr. Pugh. Thank you so much for your availability. And if there aren't any other questions, I think we can wish you all a good evening.
Oh, if I could plug really quickly, if any of our speakers or guests today would like to come and do some intergenerational work and work with our youth collective, we are starting up this September 4th and would love to kind of share some of what was talked about in here with some actual youth who are in the schools, actually kind of going through some of this. And please do fill out that form. Again, we do love feedback, and it also helps us when we partner and collab with y'all. So that's all. I'm gonna drop my email in the chat for y'all.
And thank you so much, Amani. We do have a State of Education town hall that is coming up on Wednesday night. So we will be sending out a link so that people can join us for that event on Wednesday, where we're going to be going more in depth about the budget. That is really going to be the focus of that meeting. So I do appreciate you bringing that up, Dr. Pugh. We are feeling extremely frustrated with the current state of, the current lack of of a budget, and we will be talking about that in depth on Wednesday. So, thank you everyone for joining us tonight, and I hope that you have a great 25-26 school year. Thanks.